THG PLC and Zedra Trust Company Limited.
Yes, Mr. Chasty.
Well, may I deal with this question of Daventry and glass, first of all?
Yes.
I hope you've received hard copies. I think we handed them up shortly if you didn't already have them.
Yeah.
In our submission, and I'll go through Daventry and glass reasonably quickly if I may, but in our submission, the position as adopted in glass and the reasoning why Daventry was not followed, and it was felt appropriate to do so, does not detract in any way from the arguments and submissions that I advanced yesterday. Right. The two scenarios are entirely separate and distinct, and I can take you through Daventry in detail if you wish, but obviously my lords are fully aware of the details of Daventry. And in summary, of course, what happened in Daventry was it was common ground that the obiter statement of Lord Hoffman, which everybody correctly and understandably viewed as not being binding, nevertheless represented a correct statement of the law. And at first instance and in the Court of Appeal, both sides argued the case on the basis that that obiter statement of principle reflected the law. There was no need and no opportunity for the first instance judge or the Court of Appeal to review that principle as set out by Lord Hoffman, although it is significant in our submission that Lord Justice Toulson
he was rather dubious.
Exactly. And they said that this is something that is going to probably need to be looked at again in the future. There is no endorsement, if that's the right word to use, by the Court of Appeal in Daventry in respect of that obiter statement. They were given what they were given by both sides, and they proceeded on that basis. There is no authority, as it were, coming from the Court of Appeal to say that that was correct. Indeed, two of the Lord Justices, it might be thought, probably in the back of their minds, wondered why there was being a concession that the law was correct as stated, because we don't know the arguments or what was said during the course of the hearings, but there may well have been quite significant hints from time to time that two of the Lord Justices might have thought that was tactically not the correct thing to do. It didn't matter in the end, because the rectification was found as a result of the application of the objective test, albeit there was a dissent from the Court of Appeal about how that might apply. Lords, if that's acceptable, I don't think I need to go through Daventry in any detail to explain how one finds that. What then happened in the Glass case, of course, was that in Glass, there was a contest as regards whether the non-binding obiter of Lord Hoffman should be applied, because one sees that quite squarely at paragraphs 47 and 49. At 47, the argument for the appellant was advanced on the basis that Lord Hoffman should be, the obiter should be followed. But at 49, one can see that Mr. Wolfson submitted, applying an objective test, the conclusions were correct. He goes on to say that, and then 3 or 4 lines down, when invited to make clear whether or not he accepted on behalf of the parent that on a correct understanding of the law which this court must apply, the relevant test is objective, Mr. Wolfson made it clear that he did not. And so it did arise. And so it did arise for consideration, at least, in the Glass case. And the court concluded that it wasn't bound to follow Daventry in the specific circumstances which prevailed in Daventry, as I've just described. And one sees that at paragraph, first of all, there's a recitation, of course, of the considerable criticism that had been levelled in academic circles as to the obiter statement. And those points are addressed and dealt with in some detail at paragraphs 129 onwards. But then we get at 136, forgive me. we can see that there is a reference to Kadim at the end, and Rawlinson, which itself refers to Kadim. there's no criticism or gloss or qualification that's being expressed in respect of the Kadim exception. At 137, it says, because of the assumption on which the case was conducted, the Court of Appeal in Daventry wasn't referred to and didn't consider the substantial body of case law we reviewed, establishing the need to show, and not merely objectively inferred, common intention and mistake, and in particular, the important decisions. So there were, of course, contrary Court of Appeal authorities to the Obiter statement and Lord Hoffman in Chartbrook. But the Court of Appeal in Daventry, for obvious reasons, was not taken to any of that. And at 138, you can see differences of view emerged as to how the objective test should be applied. The ultimate conclusion is effectively at 176, where it says, for all of the reasons we're unable to accept that the objective test for rectification a common mistake in Lord Hoffman's Obiter remarks correctly states the law. And then it's this sentence: we consider we are bound by authority, which also accords with sound legal principle and policy to hold. And then it goes on to say what that is. So the point being, we submit that there's nothing remarkable or controversial about the application of precedent in this context. Yeah. Obiter was not binding. There was actually previous Court of Appeal authority that was binding, and Daventry had done nothing other than to say, we're not going to get into the Obiter of Lord Hoffman, other than two of the judges felt there were some very serious question marks and it would need to be revisited at another time.
Yes.
Which means in our submission, without repeating them all of the points that I sought to make yesterday about Cherry Hill and Kadim remain entirely valid. Right. Those are our submissions on glass.
Thank you.
Well, moving on to section 9. Much has been mentioned from time to time about policy considerations in the context of limitation.
Are you going to come back to section 8 at some point?
I'm going to try to develop section 8 in my submissions on section 9. Much has been said from time to time about policy considerations and why it's policy of limitation, principles of limitation, to prevent old cases being run and clogging up, as it were court time. The position here, of course, as I sought to make yesterday, and I'll just develop this a little quickly before I go into the authorities on section 9, is if my claim for compensation is going to fall foul of limitation because section 9 and 6 years applies, then it does mean that in the context of 994s, that odd results are going to follow in terms of remedy. You have a single cause of action, which is establishing unfairly prejudicial conduct under 994. You only have one cause of action. You don't have a breach of contract and a concurrently running negligence claim in a professional negligence scenario. You have one cause of action, 994, established when the court satisfied there's been unfairly prejudicial conduct, and then a complete buffet or menu of remedies under 996. But it means that whilst I can't claim, if section 9 applies, a money claim, I could apply for a restoration of shares, or I could apply for a management order. There is then this additional oddity that it would seem logically, and I'm just going to take to Berg precision in a second, an oddity that a standard buyout order, particularly when coupled with an order that reflects the value that should have existed, but for the wrongs, might and would seem logically to be caught by section 9, but an order to require the other side to sell wouldn't.
Yeah, I think you made these points yesterday.
I did, my lord, and I'm sorry, I just want to repeat them very briefly, because overnight, and looking again at Berg precision on a different point, there are some comments that seem to support that point that I was making as to how to view.
Which decision?
Bird Precision. It's
Oh,
in
Bird
the
Precision.
supplemental
Yeah.
authorities bundle, and it's at page 16 of the bundle as paginated. If my lords have that, I'm going to come back to Bird Precision, but just on this point, there are a couple of relevant observations from other authorities. If you have, it's page 672 of the report at B, it says we've been referred to a number of authorities. First of all, to a decision in Jermyn Street, and I read an extract. Section 2 gives the court an unlimited judicial discretion to make such order as it thinks fit with a view to bringing to an end the matters complained of, including an order for buying out one faction by the other. It's not disputed on behalf of the respondents that in prescribing the basis on which the price of such a sale is to be calculated, the court can in effect provide compensation for whatever injury is being inflicted.
Hang on. Beautifully done, but you need to put the emphasis on the words "in effect."
Yes, I do.
Because, I mean, what's in fact said here is that it's actually an order that the petitioner's shares are acquired by the respondents, or possibly even the company, but usually by the respondents, at a value which is fixed to take into account the ill effects of the wrongdoing. But it still ultimately it's a share purchase.
It is.
And so, for example, the petitioner must retain available his shares to tender
Absolutely.
for the sale. I mean, he can't say once he's got his order, for example, well, actually, I sold my shares to somebody else.
No, of course not.
I still can get a monetary remedy.
I accept the words are in effect, and you have them again, my lord, in the next passage, talking precisely about this approach of valuation, and then you can see just below E, it is no doubt true that an order of this kind gives to the oppressed shareholder what is in effect money compensation for the injury done to them. I see no objection to this. And I'm merely making the point that it certainly requires, there needs to be some as it were, explanation as to why what is in effect a monetary compensation is not going to fall in Section 9 if my claim for compensation does fall within Section 9. That's the only point I'm seeking to raise, as I saw yesterday, and it's just, I was quite happy to see at least there seemed to be some support in terms of that general approach.
But I mean, if you want to enforce a contract for the sale of land, you go to the court for an order for specific performance, and you tender the land, execute the transfer, and the purchaser pays you the money. So in effect, you are getting money.
Yes.
Nobody would say that was a claim for money. So the share buyout order, you're exchanging the shares, which may be worthless, for money. That's the effect of the buyout order.
Quite clearly, it is a bilateral arrangement in that sense. But what you are here doing is you are forcing, inevitably, or else the case wouldn't fight, there wouldn't be a litigation, you are forcing an unwilling party to buy your shares, and the court is ordering them against their wishes to buy your shares, not pursuant to some underlying contractual arrangement that obliges them to do so, which they voluntarily entered into in the first place. The court is compelling them to do something they don't want to do, which is to give you money in return for probably worthless shares on this analysis.
But if the claim was a claim for breach of duty owed directly to the shareholder, minority shareholder, to the petitioner, there would undoubtedly be a limitation period, 6-year limitation period.
If there was a breach of a duty directly owed.
Right. Why is it so inconsistent with policy that where the shareholder says, well, the duty wasn't owed to me directly, but it was owed to the company in which I hold shares, why should there not be a 6-year limitation period if what's sought is a money payment?
Because there's no logic to why a money payment should be
singled
out as a remedy to be caught by limitation.
That's answering the next question I was going to get to. If somebody says, you owe me a direct duty, you breach it, I suffer loss, I'm suing you for my loss, 6-year limitation period. Why is the sort of direct financial remedy that your clients are seeking in this petition under 994, admittedly in relation to a duty owed to the company in which the shares are held, so different?
Well, 994 creates I don't want to use the word entitlement. 994 creates the platform, the power, for the judge, for the court, to grant to somebody something which they have no otherwise private right or entitlement to. They have no corresponding duty owed to them at all. They merely rely upon the statute itself, which then is silent about limitation and gives a full menu and list, an unlimited list of remedies. And so as a matter of policy, if you look at it from the other angle, from the other perspective, the question is, why would Section 996 single out some remedies to be caught by limitation and not others?
Well, that's your next point, to which the next question is, I think what you're saying is, it's odd that there should be different limitation periods for different remedies arising out of the same misconduct.
Same cause of action, effectively. That's the right phrase.
If I was to seek a buyout order, it could be, in fact, 12 years if it's within Section 8, not Section 9, for the reasons we've just been debating.
Yeah.
Whereas if you want to stay in but seek some direct monetary compensation, it would be 6. And if in fact what you did was to say, in a case where the company had suffered loss, actually the money should be put back into the company, you presumably would say that's 12, not 6, because that's not a claim by the petitioner to recover money.
Well, yes, although I can see that on a reflective loss
Well,
claim.
there'd be derivative.
Yeah.
I mean, there would be reflective loss derivative.
Yeah.
But 994 is actually designed in certain respects to get round the reflective loss problem.
Absolutely.
But why is this so dreadful a policy situation where, as compared to your case, which is there's just no limitation period for any of these things, and it's just an indefinite ability to complain?
Well, I can only go back to the point I was making, I think, in terms of why would it be such a bad policy outcome? There's no logical reason, if one starts from the premise limitation is all about trying to stop stale claims. The claim is not going to be stopped. It's just at the end of the road, for some reasons which have no obvious logic, the remedy is stopped, but I still have a trial. This case is actually potentially of some significance to this, but it demonstrates the point in a sense. Of course, before September 2020, when the Huck Group floated, it was a private company. And we claim compensation because it's now a PLC. We're never going to get, within the context of the PLC, an order restoring the equality which we say should have existed prior to what I'll call rather unsatisfactory, the share dilution or the share reallocation. When the action started, the company was not a PLC, and my client didn't want a buyout. He wanted to retain his shares. In part, he wanted to remain in the company, but in part, there was obviously an expectation that sooner or later the company might float. And therefore, the interests of the shareholder was to retain his full entitlement to shares, which when floated, would become particularly valuable.
Why do you say that you wouldn't get adjustment remedies in a PLC?
Well, it would be difficult to see how these directors or the other shareholders would themselves be able to issue new shares to allocate to my client to create the equality.
There's nothing stopping it in 994, is there?
994 theoretically won't stop it, but being realistic, the prospects of achieving an order which would affect a PLC is what may well be behind the driver to be asking for compensation. But the point that I'm making is if a party feels in a position where they don't want to be ousted out of the company, so they go for an order for restoration or issue new shares, that's not going to be bound. That's not going to be barred rather by Section 9. But if they feel that their chances of securing that for some other reasons are limited, and obviously any unfair prejudice, that they're so fact-based that one can never predict, advisors can never predict accurately or necessarily definitively what the outcome might be of the exercise of the discretion as to the true remedy. But this is just perhaps an example of a case where there seems no good reason why I shouldn't be able to get compensation for a wrong if it's happened, unfairly prejudicial conduct, because it's outside 6 years. But in a slightly different scenario, I would have got the same remedy, achieved the same result, as it were, by a restoration of shares. I've laid the point, I think. So far going directly to Section 9, the appellant raised a number of authorities: West Riding, Farmitzer, Priory Garage, and to a lesser extent possibly Hill. The short point is that actually those authorities have no real provide no real assistance in our submission to the question which is before this court, which is, does Section 9 mean that a remedy that might be granted under Section 996, which includes compensation, or which is compensation, is barred? The West Riding case, again, my lords have looked at these already in some detail, and if I may, I'll try to make my points reasonably quickly without taking you to pages and reading paragraphs and paragraphs unnecessarily. But the point made in West Riding, of course, is that what was being done was a construction of the relevant legislation, which used the word adjustment, that when local authorities were taken over one by another, it was possible for a party, an authority, to ask for an adjustment to be taken, and the procedure was first of all that there should be agreement to that effect if possible, and failing agreement, the matter should be referred to an arbitration. It's at page 1265, and that's tab 37, and you can see at page 1269, sorry, I should just take you to 1266, that's where the relevant statutory provision is to be found. Any public bodies, at the bottom, any public body is affected by any alteration of areas or authorities made by an order under this part of this Act may from time to time make agreements for the purpose of adjusting any property, income, debts, liabilities and expenses so far as affected by the alteration of any financial relations between them. And then subparagraph 3, in default of an agreement, any matter requiring adjustment, such adjustment shall be referred to the arbitration of a single arbitrator. And then,
so if you look at what the agreement may provide for in section 1512, it can provide for the transfer or retention of any property, debts and liabilities with or without conditions, joint use of any property, transfer of functions and payment.
yes,
So you could have a local authority which said, well, we want the joint use of the recycling facility.
yeah.
That wouldn't be a claim for money.
No. What the court did in here, though, is they said quite clearly, this is a claim for money.
Yes.
That's what this is about. And the adjustment in question is money. And
Absolutely. But the point I'm putting to you is that section 1512 gives what you've described as a menu.
Yes.
All sorts of different things that the agreement might wish to provide for.
Yes.
It could be joint use of property. It could be saying, well, we'll keep the town hall. It could be whatever.
It's the point is, and obviously this is a point that I'm advancing, and it will find favour or it won't find favour. Is that when you look at all of the statutes which it said attract Section 9, there is a specific reference
Yes.
to money. You might have a list of various things, but one of the things that you have is money. And in 996, you don't have that.
Yeah.
You have an unlimited discretion, and you have certain matters mentioned, and you don't have money. And the central, and as I say, my lords will find this favour in this, or you won't find favour. But all that these authorities do is identify that in the particular facts of the case before them, the relevant statute provides for the payment of a sum of money and prescribes for that. And in those circumstances that the matter falls within Section 9. And you can see that stressed at 1271. The first main paragraph. In my opinion, this is a money claim, and the arbitration is one to recover a sum recoverable by virtue of an enactment. Section 151 provides for this adjustment. So all that, and at the bottom, in my opinion, this is really when the realities of the transaction are looked at and the documents to which have been referred are considered, simply an action to recover a sum of money by virtue of the provisions of Section 151. One of those provisions which specifically says you can have money.
I understand your submission, but can you just help me on this? Why can it not equally be said in the present case that your client's claim is a claim to recover a sum of money by virtue of the provisions of Section 996
Well,
of the Companies Act?
I fully anticipated, my lord, making that point. It requires acceptance of my argument that Section 9 is limited to those statutes which expressly provide for the payment of money. The relevant statutory provision itself specifically provides for the payment of money, whereas what 994 and 996 here are doing is simply providing a platform which, if unfairly prejudicial conduct is accepted, gives rise to a full wide discretion. But it does not entitle my client to say, under an act, I require you, the respondent, to pay me money, in the same way that the authority under Section 151 was entitled to do, nor liquidators under 214 can do, where they can go to court and say, I have a statutory entitlement to claim a contribution from you to the pot of the company in order to pay creditors.
So to be clear, your contention is that when the statute uses the words, quote, any sum recoverable by virtue of any enactment, we read in an implicit limitation to enactments which specifically provide for the payment of money.
Which specifically provide for the payment of money, and which also provide an entitlement of a party to sue on that statute for that money, in the same way that happened in West Riding. The statute creates effectively a cause of action for that payment of money on the basis that the circumstances within the statute itself have arisen and justify that obligation. It creates a duty on the part of the party to pay.
So, if I've understood it correctly, you're saying if the statute says the court shall have the power to grant any remedy it sees fit, you say Section 9 is not engaged. If the statute says the court shall have the power to order compensation, then you say it is engaged, or order a payment of money, something which essentially is the payment of money, Section 9 could be engaged.
Yes.
And if the statute says the court shall have power to make whatever order it thinks fit, including in particular payment of money, what's the answer?
Well, it would probably be rather like in West Riding, because there it's specifically provided for the payment of money. It's the express provision point that I'm seeking to stress.
Right,
Yes.
so you say without the express provision.
Without the express provision. Because the express provision doesn't just provide, my point is, I think, that the express provision just doesn't simply provide the power of the judge, and he's being told you've got that power, and if you didn't realise when we said everything, it includes money, so here it is. But it also enables the party relying on that section to sue on that section and say, you owe me money under this section. 994, 996 don't, as such, give me any right.
Well, can I ask you a last question on this point, which is, what would you say to the proposition that what Section 9.1 is getting at is whether the claim for money depends upon a statute, and that in the present case that condition is satisfied because your client's claim does depend upon sections 994 and 996, because without those sections you couldn't bring it.
Well, again, that's effectively the point I think that my lord was putting to me at the start. One has to try to do one's best to look at 994, 996 and Section 9, because it may well be that because of the understanding that the law limitation has no application to 994s at all, and that's been the understanding for 40 years, and that was the Law Commission's view, Section 9 has never been reconsidered in the context of its application to 994s. But I say that really it's a fundamental point about 994 and 996. The whole structure of 994 and 996 is just not logically amenable to an application of Section 9. In part because of the illogicalities and lack of good justification for saying you can have some remedies but you can't have another. And would Section 9 be intended to have that effect? My lords, I think that probably, I probably made my point, if I may say, through my lord's questions about this, about the other authorities already in a sense. The other points that I'd want to make is that we don't in our submission see that there's justification for trying to extract from the West Riding case any support for the proposition that you simply look and see as to what the remedy is. What West Riding was actually doing was focusing on the particular statute and identifying the rights of the party to sue on it. There's no look and see obviously coming from West Riding, although it then seems to have been a proposition that seems to have gained traction subsequently. And what we say is that, with respect, is questionable in terms of its correctness, because the fundamental question is, does Section 9 apply to 994 and 996? That's the question. You don't answer that by saying, well, you're claiming a remedy that's money, and therefore automatically 9 must apply. The question is a more detailed one, a more substantial one, which is what is the application of Section 999 of Section 9, and you don't answer that by just, in our respectful submission, looking and seeing. And so we would question the validity of that approach with respect. And I think beyond that, farm itself is again just an example in our submission of a statute being construed and it being concluded that a contribution a contribution includes money, and that gives rise to understanding. And the discretion point, again, we submit is not is not of real relevance to our situation. If you have an entitlement under the Act to ask for money, and that is what triggers your claim, the fact that the court then in its discretion can deal with that in part or in whole or not at all doesn't take away from it falling within Section 9. But when you hear, we have the discretionary element first, not the entitlement first under the Act. And so we respectfully submit that Farmitzer on discretion doesn't really provide any guidance either.
Well, you say Farmitzer is a case which expressly provided for
Yes.
a payment of money. Therefore, the fact that other relief could be available conceptually under the section doesn't.
Exactly. But
That doesn't mean. Sorry, it means it can fall within Section 9 if somebody does in fact claim money.
my lord, yes. I think the point that I'm trying to make, well, not terribly elegantly, is that first of all there needs to be an express reference in the relevant Act, and the concept that what that does is that creates the right to pursue for that money, because there's an express reference to it that you're then relying on, and it equally imposes, perhaps rather like Lord Leggett was saying in Smith, in the context of 140s, although he put it the other way around, it creates a duty on the part of a party to pay money because of the statutory obligation to do so, whereas 994 and 996 simply don't do that. The only other, my lords, if I may, I won't trouble them, my lords, take up my lords' time going through Farmitzer and the other those four authorities, because I said they all fall into the same pot in terms of what do they actually do. The only other authority on this, which my lords may or may not find of some broad assistance, is the case of the Royal Mail group litigation.
Mr. Justice Mann makes the point you've just made.
My lord, that's it. So my lord's got it. It's paragraphs 191, 92. In relation to that exact point. My lord's ahead of me. My lord's got my point. I'm not going to trouble my lord's reading the point that you've already got.
Yes, but not all of us are as quick.
Oh, I'm sorry.
Have a quick
Lord, the point is, I think, just to put this in context, I think there were 12 or 13 issues that were raised for determination. One was whether or not statute provided for duties in the first place on the part of the respondents to do certain things, and it was held that there was no such duty, and therefore effectively that was an end of the matter. But the question was posed about limitation, and at paragraphs 190 under the heading action for a sum recoverable under a statute is 192. It was argued that if there had been a duty, a 6-year period applied. And at 192 it said the trouble with this argument is that the regulations say nothing about money or recovery of money. On the hypothesis of this part of this judgment, they impose an obligation without saying more about its effect. The cases cited to me were where the statute in question specified not only the cause of action, but also specified a remedy, and that remedy was money or an equivalent. And then it goes on to talk about Farmitzer. And at
my recollection of this case is that that's not what the claimants wanted. They wanted
invoices.
They wanted an order that Royal Mail should provide them with VAT invoices.
Yes.
So they could then go off to HMRC and ask for their VAT back. I'm not quite sure why this issue arose at all.
It's posed as an issue. There's a whole list of issues, and it's posed. But
certainly, when it got to the Court of Appeal, there was no question of the claimants wanting any money relief at all. They wanted an order requiring Royal Mail to provide them with VAT invoices.
Lord. But I quite like, if I may say, the analysis at 192
yes,
and
yes,
193.
Well, 192 and 193 is exactly the point you've been making.
Lord, yes. My lord, it has something to say also, I said I'd try to touch on specialties. It has something to say about specialties, starting at 181. I'll come back to just Hill in a second on this. As I've already said, my lords, if it were to be found, perhaps it might be said, bearing in mind everything else that's been said about the law, to some surprise that Section 8 applies, this appeal still fails. So to that extent, just because Section 8 applies, it doesn't obviously follow that Section 9 applies. My lord made the point, well, it rubbishes, my word, not my lord's, it rubbishes the proposition that no limitation applies. But if Section 8 applies, but that doesn't harm me.
No.
That doesn't harm me. But I do, my lords, for what it's worth, just draw my lord's attention to the analysis in paragraphs 181 through to 187.
This touches on a point which maybe you can certainly help me with. This Justice Man there says that some claims under some statutes, specialties, and I, just looking a little bit, my understanding of specialty rather simplistically used to be that it was essentially limited to claims under contracts under seal.
Yes.
Which is where you find it mentioned most often, perhaps. What I'm struggling with at the moment is to find out whether it applies to every claim under every statute, or, as Mr. Justice Mann says, some claims under some statutes. But if so, how do you figure out which statute?
The only possible point to make about that, I think, is that in Hill, having to jump about to try to answer my lord's point. The way in which
just before we go to Hill, can we finish on this case?
Sorry, yes, I was just trying to answer that.
Because why does this case not provide the answer? Because Mr. Justice Mann cites from Colin, which is decision of this court binding, also cites incidentally from Rahman on the same point. But just sticking with what he cites from Colin, which in turn refers back to alia, and one can just focus on the second quote, which is Lord Justice Oliver himself. Broadly, the test is whether any cause of action exists apart from the statute.
Yes. When one looks at Hill, there's a slightly fuller reference to what a specialty is, which I'll take my lord to. I think the point is...
I think there's quite a lot in Priory Garage as well. I think Mr. Randall quotes quite extensively from Colin.
He does, and I think he quotes the same quote that I'm about to show you. The point is, it doesn't apply... The question is, does every single statute attract Section 8? That was my lord's point, and what's being said there is some do, and it's a question of trying to discover which do and which don't.
Yes, but what I'm suggesting to you is that statement might be wrong, and that the correct answer is the one given by Lord Oliver, namely, it's a question of whether any cause of action exists apart from the statute, and that applies to all statutes. Now, what's wrong with that?
What I say, my lord, and I'm sorry, but I will show you Hill in a moment, what I say is what the statute has to do is create an obligation. In order to attract Section 8, the relevant statute has to create an obligation or a duty. And 994 and 996 don't do that. May I just do this, my lord? I hope you'll forgive me. If I just do take you to Hill, it makes the point as to how it's put by Lady Justice Arden, as she was, at page 760 at tab 21. At paragraph 116 at the top of 760, she refers to specialties, and she says at 116, insofar as the relief sought is not to recover any sum recoverable by virtue of enactment within 9, I agree with the judge that this is an action for a specialty. And then she says this, the action of a specialty is a covenant under seal or an obligation imposed by statute. and then there's reference to authority. In both the cases cited, the claim was to recover a sum of money under a statute. C, this court didn't determine whether such a claim was a specialty, but we've not shown any authority which establishes that an obligation imposed by statute other than to pay money is not a specialty. But the point is about obligation, and we just keep going back to the same place, which is
I wonder if
994.
you're right about that. If you go back to Mr. Justice Mann in the Royal Mail case, paragraph 183, he refers to Rahman, sterling credit, right to reopen an extortionate credit bargain, gave the Act gave the power to reopen and relieve the debtor in whole or in part from the obligation to make further payments. And Justice Mummery held that Lord Justice Oliver's reasoning applies. That reasoning applies to the statutory right of a borrower to make application to the court under section 139. Cause of action arises only out of the 74 Act. Apart from those provisions, Mr. Rahman had no right to have the loan agreement reopened. That's not about imposing a duty. And as we know from Smith and RBS, Rahman was approved by the Supreme Court.
My Lord, I take my Lord's point. My point is that if one looks at Hill and what the statute has to do, 994, 996 provide no rights at all.
No, I follow that.
That's my point.
Yeah, that's your point.
That's my point, my Lord. And really, and then the final area, my Lord, just to seek to address, are the points that I dealt with in our supplementary skeleton, which we provided only a couple of days ago, and I can make these points.
Let me just find it. Yes.
Reasonably quickly. It goes to the question of.
Sorry, which document? I'm sorry.
We provided the
supplemental note.
5th of February, I think. Is it the 5th of February? It say on the top, my Lord, I think.
Yes.
Yeah.
Supplemental note, 5th of February.
Yes, it's that one. So the point, this goes to a somewhat different point, but nonetheless it's of some relevance.
Yep.
Obviously, sections 8 and section 9 both talk about the cause of action accruing.
Yeah.
And so the question is, I thought, my Lord, I can see my Lord Justice Arnold. If I got that wrong, Lord, forgive me.
Section 9 doesn't.
Forgive me.
Oh, sorry, I misspoke. No, you're right. It does. It
Thank you.
does. Sorry, I was forgetting the words at the end.
I was about to
Yes.
think that my whole point I was about to make was completely.
No.
It may well be flawed, but I didn't think it was flawed for that reason.
No.
Can we restart the point? Sorry, I've lost the thread.
It goes to the question of the point I'm about to make now. The final point I'm making now is that a consideration to be drawn if section 9 is to apply, is when did the cause of action accrue? And Smith is of. I'm not going to take you to Smith again, but Smith is of some at least analogous relevance in the sense that in the context of those statutory provisions, the court determined, or the Supreme Court said, that until it's decided that there is an unfair relationship, you don't have a claim, and your cause of action accrues on the determination that you had an unfair relationship. And we say, by analogy at least, with Smith, the position is with an unfair prejudice, and it goes back to my points that I've repeated several times, that 994 doesn't create any rights for a shareholder. They don't have anything to sue on directly. They first of all have to go through a gate. They have to establish that a gateway exists, and that is that unfairly prejudicial conduct has been carried out. If the court is satisfied of that, then, and only then, it can go on to consider whether or not to grant a remedy under 994. And if I could just, my lords are more than now familiar with, obviously, the precise wording of 994. But 994 says a member of a company may apply to the court by petition for an order under this part on the ground that the company's affairs are being or have been conducted in a manner that is unfairly prejudicial to the interests of the members. And 996 says, if the court is satisfied that a petition is well founded, it may make such an order as it thinks fit.
But isn't that what the court is always doing? You place the facts before the court decides whether your claim is well founded, and if the court decides that it is, then the court grants you a remedy.
But I have no pre-existing, and I don't have a contract, for example. I've not fallen over in the street where there's been a breach of a duty by the highway authority to repair.
Would you say that the Secretary of State has no cause of action to disqualify a director until the court's decided he's unfit?
I hadn't thought that through. But
there are lots of evaluative judgments which the court is called upon to make. It would be odd if in those cases, some of which are statutory and some of which are not.
I suppose the Secretary of State can't unilaterally disqualify a director. He can only do so through the court itself concluding that the director is unfit.
And there is a time limit for making such an application without leave. But
yeah,
what I'm asking you is, does he have a cause of action at all? You say he doesn't.
No,
never does. What he does once the
he has an entitlement to come to court and ask the court to make a determination under the statutory.
Once the court's decided a particular person is unfit to be a director, so there is a cause of action, which.
That's sort of the point that I was trying to take from Smith, that until the court has determined that the relationship was unfair, there's no entitlement to any remedy.
It seems very odd that a cause of action does not arise until the court's decided something.
Well, the points are made. Those sort of points are made in the Bird Precision and the case of Mr. Justice Scott in Re-Amended Petition.
Before we go into the authorities, can I ask you the same question in a slightly different way? Would you dispute that on the facts that we're concerned with in this case, your client's cause of action arose on the 11th of July 2016?
I don't think I can accept that because it breaks down my argument. What it does is it entitles me to come to court to ask the court to determine that behaviour was unfairly prejudicial, which then gives a gateway into section 996. But it doesn't give me a right to go direct to
So that seems to involve an acceptance that your clients have got no cause of action at all. So why are they in court?
Well, they have a statutory right to come to court to ask for the court to determine that they have a remedy.
So you're saying it all hinges on the words at the start of 994, which gives you a freestanding right to come to court, irrespective of whether it actually turns out that you have a cause of action.
Well, yes.
I mean, so
because that's what the court is going to decide, whether I do or not.
I'm struggling to see why this is so different from just the examples you gave. I mean, a share is just a piece of property, and there may be, so for example, in the general world, something which I own is damaged. I claim it's damaged by the negligence of somebody who owed me a duty. I come to court with a cause of action because somebody who owed me a duty breached the duty and I suffered loss. Where you own a share in a company, you're claiming that somebody who in fact owed a duty to the company but nonetheless did something which damaged my shares. Well, why isn't that immediately a cause of action?
I wouldn't accept that in unfair prejudice petitions you are suing on a duty. The shareholder is necessarily suing on a duty that's owed to them by the respondent.
No, they're not suing on a duty owed to them.
No.
But they are claiming that a piece of property which they own was damaged by the acts of somebody who breached a duty owed to the company.
But they have no direct claim as a consequence of that, in the same way that they do if I make a contract with somebody and the other person breaks it. directly against them. I go through 994. 994.
So you say the difference is the absence of a direct duty.
Yeah.
But it's that which differentiates 994 or 994 996 from
994 is, as my lord I think said, is you would not, and there's a whole host of authorities on this point, and we had an argument about this. Number one, you wouldn't be able to, you wouldn't be expected to be able to bring a reflective loss claim directly against the shareholders in respect of loss to the company. But the common basis of an unfair prejudice claim is that a director shareholder has wrongly misappropriated assets belonging to the company. That's on its face an obvious derivative claim if it's going to be pursued. But 994 enables you, notwithstanding the fact that you have no duties owed to you as a shareholder, to seek a remedy in respect to
it's quite difficult, isn't it? Because the classic, we're talking here about breach of duties by directors giving rise to 994 proceedings, which is a classic. But equally classic is a breach of the articles.
Yep.
Which enables you. So suppose the company passes a resolution contrary to the articles, which inflicts prejudice on the shareholder. Now, the shareholder does have a direct contractual relationship with the company on the terms of the Articles of Association, and that would be the basis for the 994 petition, i.e. this resolution was passed in breach of the articles. It's unfairly prejudicial to me because it's damaged the value of my shares. Are you saying that when does the cause of action arise in that sort of case?
Well, again, it arises in the context of a 994, if I choose to go down that route, when the court says you've been unfairly prejudicially treated. The fact that... Sorry, Mom.
Sorry.
The point is that this analysis, these exchanges from the Lord, and how an underlying claim could be differently formulated, as it were. The underlying claim bringing 994, in our respect, which supports the whole reason why Limitation Act has got nothing to do with 994.
So
because you're going to get into
that point, I understand, but I'm still struggling with the earlier point, and I'm sure I'm being dense about this, but I suggested to you that your client's cause of action arose on the 11th of July 2016. You said no. I think, but if I've misunderstood, please correct me, that in response to my Lord's suggestion, you disputed the proposition that the cause of action arose when the court gave judgment. And that only seems to leave the logical alternative that when I put it to you before, you denied, namely that there is no cause of action.
Well, I think what I'm saying is my entitlement is purely statutory under 994. To that extent, if I'm going into specialty territory, okay. But my entitlement is to say to the court, there has been a course of conduct over a period of time which does not give me any direct claim per se against anybody.
So the cause of action accrues when the court gives judgment?
Yes.
Right, sorry, it's my fault. I misunderstood your answer. So you say, in terms, cause of action accrues when court gives judgment, not before. And
I say Smith is of some assistance to that, because Smith is saying, there's nothing unique about the 994, and therefore there's nothing unique about 140, because no statutory provisions.
What do you do with this cause of action once it's accrued? Nothing.
Well, when it's accrued, you've got your judgment, and you enforce your judgment.
And how do you square that with the doctrine of merger?
Well, this is an entirely unique territory that we're dealing with under 994. I don't see with respect, any difficulties in that. And that the whole point is application of limitation principles completely destroys 994 and 996 for the very reason, if I may say, of the analysis that my Lord or Justice Snowden was embarking on. If a judge starts to be required to carry out an analysis of what types of claims are being advanced and how they might be described in another setting, as it were, to then have a tick list and say, you're barred from pursuing that, you're not barred, then that completely undermines 994 and 996.
I mean, as I now understand what you're saying that this idea of a cause of action, which is characterised by the dictum which we've not looked at but have all mentioned in the Tang and Cooper, is very much a common law creature.
That is what I think.
And it's not opposite to... You just don't apply it. It's just not applicable when you are looking at a statute which very specifically is formulated in a different way, namely a member of the company may apply to the court, or, as my lord put it to you, the Secretary of State may apply to the court for an order for a disqualification.
And that is the point, really, that in very short, succinct terms, Mr. Justice Fancourt was making in his judgment when he talked about this is a petition. It is a petition to the court, asking the court to make such orders as it thinks fit. The slight hiccup, as it were, in just trying to follow that through is that, and it may be a historical provision, is that the definition of action for the purposes of the Limitation Act include those words, any proceedings in a court of law. I'm afraid I haven't checked it, but I rather suspect that they follow from the 1939 Act, and that definition has not been changed. Whereas petitions for unfair prejudice cases didn't come in until 1948. But the word...
No, unfair prejudice came in 1980.
The 1940, the earlier provisions in respect.
It was oppression.
Exactly.
And actually, but that actually leads to the very next point. I mean, this formulation, you can apply to the court by petition, or you can apply to the court, I think was the wording for the old oppression, section 210 of the 48 Act. I'll have to check it. Somebody might.
I'd have to check.
I can check it in a minute, but and certainly is the case which, in relation to how does it fit with the just and equitable winding up regime? You'd say the same approach applies, would you? That there's no limitation period in relation to just and equitable winding up petition, which would explain, you say, why nobody has ever tried. That there just are no reported cases suggesting that Section 8 applies to a just and equitable winding up petition.
Exactly.
It's not because it's, quote, a petition, it's because of the nature of the process.
I was probably just trying to sort of shorten it by using the word petition, but it is the whole process. It's what I've endeavoured to try to stress, that 994 creates this platform to enable you to go to court when you have no other rights. And for example, quasi-partnership is you have no contractual rights as such within a quasi-partnership. You are obviously you're not in palm tree justice, of course you're not, but there is such a breadth of multifacets to a quasi-partnership type case that to start trying to apply limitation principles to that is extraordinarily difficult. But I think those are really my points. The last point, just to remind you, I'm not going to take you to, is that Mr. Justice Scott made the point in Re-Amended Petition back in 1987 that when an application was made for an interim payment, he had no jurisdiction to do that. He had no jurisdiction to make any order at all until such time as it been determined that there was unfairly prejudicial conduct. And I merely say that is consistent with the approach that we're trying to invite the Lords to adopt. Yeah. Lords, unless you have anything, I don't have anything more to say.
No, thank you, Mr. Chasty. Mr. Ashworth, do you wish to reply?
My Lords, briefly, I hope. Well, as I say, nothing further about ground one has been gone over. Nothing's been said today changes the Cadime principles. No suggestion that Cadime is not the right principle to apply. We've said how you should apply it. The Smith and RBS, paragraph 58, your Lordship, Lord Justice Lewison recognised it was clearly obiter, but then suggested it was of some weight. May I suggest that Lord Legate would certainly not hold it was any part of the ratio on his own analysis of young Sam. It clearly wasn't part of his best and preferred reason decision in Smith. He made no analysis of section 8 or 9 or how limitation might apply to a section 994 petition. So notwithstanding that he sits in the Supreme Court, it actually gives this court no assistance at all. My Lord, time and again, my learned friend seems to suggest that there would be floodgates and insuperable problems if this court were to hold there was a limitation period. But there are no such problems. The obstacles that he seeks to raise are illusory. There are simply no difficulties at all, and I'll come on to deal with that a bit more. The answer, I think, to your Lordship's concern, or Justice Lewison's concern, that recognising limitation period for unfair prejudice complaints would lead to stale complaints with limitation period being litigated through to trial because they could not be struck out for want of prosecution. That simply doesn't arise. There's still the possibility to strike out when there's been something more than mere delay, which is delay simpliciter. And in extreme cases of delay simpliciter, a respondent could apply to strike out and say there's just no basis on which this court would ever grant relief and therefore strike it out. Alternatively, apply for reverse summary judgment. It would also be open to a respondent to raise the defence of late cheese in an appropriate case, apply for reverse summary judgment to renounce the defence before the limitation period had expired as well.
Well, I'm not sure about late cheese. That applies to equitable remedies. So that raises the question, are you asking, if you go to court under section 994, are you asking for an equitable remedy?
Well, we say you're not, my lord. So
late cheese doesn't apply.
But delay and acquiescence does apply. So if late cheese applies, you can. If it doesn't, delay and acquiescence. This claim is and only could be a claim for compensation. And it's not open to Zedra now effectively to try to game the system. So it could have been put various different ways, because that's not what they are trying to do in this case. And nor is it open to any other petitioner to game the system by not being specific about the relief they seek. A buyout order, I'll come back to that point in a minute, but just illustrate by buyout order. A buyout order is not properly analysed as a claim for money, because what you usually end up at the end of the trial is an order requiring one party to buy the other party's shares at a valuation, either which the court gives directions to how that valuation should take place, and there's never a money order, or occasionally the court could say at £100,000. The court could, if it had the evidence, put a particular figure on it. But it isn't then a money judgment. It's simply saying you must enter into this transaction on these terms. And therefore, I think it's the point Lord Justice Lewison was making this morning. Section 9.1 doesn't arise. The gaming issues that Your Lordship, Lord Justice Snowden raised simply don't come into play.
Well, the possibility of gaming just doesn't arise if there's no limitation period. If there's no limitation period at all, then in a sense there's no opportunity to game the limitation periods. You simply bring your claim for a remedy, and the court just decides on the usual reverse summary judgment or strikeout basis whether there's any prospect of you getting it, and strikes you out if there isn't. Otherwise, you go to trial, and the court decides at the end of the day.
Sorry, I must have misunderstood the point Your Lordship was making. I thought you were making it in context of being a Section 6, Section 12 dichotomy. But effectively, you could get around Section 6 by saying, I want to... If buyout order was a money judgment, I think this is the hypothesis, it might fall within Section 9.
I think the point, we will have to retrace my steps mentally, but you say limitation periods do apply.
We do.
And then we get into questions of which limitation period is it dependent upon the type of relief that you seek in your petition, and the question about whether parties could game the system by claiming certain relief but not others then arises. The point against you is if there is no limitation period, all of that falls away. There's no possibility of gaming the system.
But I'm saying
there's
no possibility of gaming the system even if there are limitation periods. And Your Lordship premised the idea of a buyout order possibly being a money order, and therefore the petitioner say...
You say it isn't.
But the idea being the petitioner says, I will have an order that I buy the majority shares, I have a purchase order, which isn't a money judgment, therefore I get within 12 years, I extend the limitation period to 12 years. But that doesn't work because the buyout order isn't a money judgment either way, so they're both 12 years. But even if it did, my lord, the effect would simply be to say, when the court comes to grant the remedy, that remedy would be barred. So if your lordship's right, and the petition was brought on an act which has ceased more than 6 years before the petition was brought, you simply say, right, at the end of the day, the remedy I can't give you is that one because that's barred by limitation.
And so, I mean, I think you'd argue as follows, as I understand it. Suppose there's a course of conduct. Let's say it's a 50-50 company. If the course of conduct takes place more than a certain period prior to the petition being presented, you'd say the person couldn't claim a buyout order. Or could claim a buy-in order?
No,
Or you say in both of those would be subject to a 12-year limitation period.
Both subject to 12-year limitation period. But if I'm wrong on that, and a buyout order is somehow a money judgment, then all it would do would prevent the court at the end of the trial from awarding that remedy.
Yeah, but your primary point is there is a limitation period, but it's the same for both buy-in and buy-out.
And it would be 12 years under Section 8.
You have some support for that in the decision of Mr. Justice Scott, to which we have been referred, where if you go to tab 3 of our supplemental authorities, page 44 of the bundle, page 580 of the report, one of the submissions that was made was that a buyout order would represent a judgment for a substantial sum of money, and Mr. Justice Scott disagrees. He said it will entitle the petitioner to money when but not until he tenders the share certificates. There's no debt owing. There will be no debt owing until first an order is made. Secondly, there's a tender of the share certificates against the purchase price.
Lord, yes. Before the rules of Part 36 were changed, it was impossible to make a Part 36 and a 994 because you couldn't just offer, when Part 36 just, I'll pay you a sum of money. You couldn't do that. And it was all connected with this. But the Part 36 can change, you can make a Part 36. But that was the whole point, that you weren't, at the end of the day, if the relief sought was the buyout order, you weren't getting a sum of money. And the whole rationale for I can't give you a payment on account is because it doesn't fall within what is now CPR 25, payments on account. So my lord, we say that the potential gaming issues that your lordship raise, if you don't occur, then your lordship raise the question of just and equitable winding up hypothetical. In practice, it's never going to rise for determination because Section 1221G requires the court to determine whether it is, in the present tense, just and equitable, to make a winding up on order in the circumstances as they stand at the time when the court is asked to make the order. So no limitation period. The reason there'd be no cases by the way, because no one in their right mind would bring a just and equitable based on something which happened 6 years ago, more than 6 years ago, and no longer continued. Because my lord, one can imagine a situation where you've got a deadlock 7 years ago. That deadlock ceases. The just and equitable would inevitably fail because there is no longer just and equitable wind up as things stand at that time.
If there's a continuing course of conduct, that could span.
Well, absolutely, well, yes, but the continuing course of conduct can span this as well.
Right. So you'd say if the course of conduct, which ultimately it said makes it just and equitable, namely, let's say a deadlock, for example, you say what you can or you can't rely upon events more than 6 years.
You can't rely upon events more than 6 years. If the deadlock continues in the last 6 years up to the time of the hearing of the just and equitable winding up,
And is the answer that you can rely upon events pre 6 years as evidence or to put into correct focus what happens within 6 years, but not as independent grounds for complaint?
Yes, that's the Southern Counties type approach, where you can look at the history in order to inform the current, as it were. If it's a one-off event which has happened and finished, then that's the end of it.
And that's what the Law Commission thought too.
My lord, yes. Smith and relief, my lord. What Lord Leggett held is there was a 6-year limitation period under Section 9.1. Once the relationship had come to an end, or the court has determined the ongoing relationship is unfair. An important point about Section 140A, which I think you've been handed up today, is it is unfair, not has been unfair. And as his lordship said, it's in paragraph 42 of the judgment.
Which tab are we in?
Tab 34, my lord.
Paragraph 42.
Paragraph 42. This was the completed cause of action argument was flawed. All the courts below, including the Court of Appeal, rejected this argument, in my opinion, were quite right to do so. The central flaw in the completed cause of action argument is that for as long as the credit relationship is continuing, the debtor cannot have a completed cause of action before the time at which a determination of unfairness is made. Proof of facts which made the relationship unfair to the debtor at some earlier point in time is never sufficient to give the debtor an entitlement to a remedy. This is because, as noted in 90 to 21 above, unless the relationship is ended, Section 140A makes the power of the court to make an order under Section 140B conditional on the determination the relationship is, by at the time when the determination is made, unfair to the debtor. Necessarily, a right to obtain a remedy for unfairness existing on that day cannot arise before that day comes. So the statute is specific. You're looking at the current situation at the time the matter is before the court. Whereas Section 994 is not current. It's current and past. So you can have it prospectively, as Lord Justice Snowden said yesterday. But you're looking at historic acts. And
is this your point about 1221G?
my lord, yes, it's the same point. 1221G is looking at the time it's before the court. So 44 and 45, he then explains that for as long as a credit relationship lasts, no cause of action accrues which the debtor then has a period of time in which to sue for remedy under Section 140B. Any entitlement to remedial order arises from a set of facts which is complete only at the time when the order is made. And at 45, once the credit relationship ends, the position changes. The determination of the relationship was unfair to the debtor on the date when it ended can be made on that date or any later date. All the facts around the determination are fixed when the relationship ends. Nothing that occurs subsequently can affect the assessment of fairness. It can therefore be said the cause of action has accrued, so the period of limitation starts to run. And while in this case, my lords, can I just ask you to look at paragraph 48, which dealt with the predecessor Section 140A to 140C, which was sections 137 to 140 of the 1974 Act. Under which the court had power to reopen a credit agreement so as to do justice between the parties. It found the credit bargain was extortionate. In reopening such an agreement, the court had power to grant a range of remedies, including an order requiring the creditor to repay the whole or part of any sum paid. Case law established the period of limitation for such a claim depended on the nature of the relief sought. Insofar as the debtor was seeking relief from indebtedness incurred under the credit agreement, the claim was an action upon a specialty, for which Section 8 prescribes a limitation period of 12 years. Insofar as the debtor was seeking repayment of payments already made under the credit agreement, the claim fell within Section 9, which is already noted, prescribes a limitation of 6 years. In each case, the cause of action accrued when the credit agreement was made. So the point there is there's no difficulty in having two different limitation periods for the same cause of action accruing under the same bit of legislation. So there's no difficulty for there to be a Section 8 limitation period for something which is not claiming money, and a Section 9 limitation period for something which is causing money, even under the same provision of the same Act.
Okay, similar point, or it's a derivative point. Sorry. I've just brought up section 210 of the 48 Act, which is the statutory provision which was replaced by the 1980 Act, unfair prejudice regime. And that says any member of a company who complains the affairs of a company are being conducted in a manner oppressive to some part of the members, including himself, may make an application to the court by petition for an order under this section. So in one respect it's similar to 994. You can make an application to court by petition. But there's one difference. It says if on any such petition the court is of the opinion that the company's affairs are being conducted as aforesaid, and that to wind the company up would unfairly prejudice that part of the members, but otherwise the facts would justify the making of a winding up order on the ground it was just and equitable, then the court may, with a view to bringing an end to the matters complained of, make such order as it thinks fit, whether for regulating the conduct of the affairs or for the purchase of shares, etc. So section 210 of the 48 Act seems to have a hybrid. It seems to be using the petition approach that Mr. Chasty was emphasising of an application to the court, but it also is only couched in terms of section as an alternative to section 122(1)(g), namely the court must be satisfied that the affairs are being conducted, and as an alternative to making of a just and equitable winding up order.
It's a present tense requirement, my lord, yes.
So is this right? You'd say that the reason why nobody had suggested that there's a limitation period in relation to section 210 of the 48 Act is that no cause of action arose until the court has made an order or satisfied itself it's going to make an order?
Well, it's got to be, yes, it's got to be current at the time. So the court has to be, so it's like Smith, it's a present tense analysis.
In other words, the petitioner has to allege under section 210 that the affairs of the company are being managed in such a way,
Yes.
etc. And if you were to present a petition which says, well, 6 years ago the company's affairs were being managed in a particular way, you would be able to strike it out as not coming within the section at all.
My lord, yes.
Well, and you have to be satisfied that that the facts would otherwise justify the making of a just and equitable winding up order, which you say is a current
We do, my lord, yes.
thing. So now, if in fact that's the explanation why there was no cause of action, but does that doesn't address the question of why section 8 wouldn't apply, does it?
Well, section 8 might, yes, section 8,
Because there's two big mysteries here.
Section 8 would apply, my lord.
Yeah, but there's two big mysteries here. One is why nobody, including the Law Commission, had actually said there is a limitation period here. It's section 8, because this is a claim on a specialty. That's one big mystery. I mean, I know you said 12 years, poof, you know, such a never make any difference, but nonetheless, it's there. And then the second big mystery is why nobody has ever said section 6. Now, I know you're attacking the
Section 9.
Sorry, 6 years. I know you're attacking the section 9 for obvious reasons.
Yes. It starts with section 8, because section 8 it's a claim on a specialty. And then section 8(2) says that won't apply for some other.
Of course, but none of the arguments that you're currently addressing in relation to section 9, you know, which are quite technical about when a cause of action arises and this, that and the other, and whether it in fact it's a claim to recover money under an enactment. None of those solve the mystery as to why nobody's ever asserted that there's a 12-year limitation period.
Well,
Well, it may be because it simply wouldn't apply to section 210 because it's all about what is happening now.
you never get that far. If if you applied under 210 for something which happened 14 years ago, you get struck out, as Lord Justice Lewison says, for not complying with the section.
But except there are many, there are cases, and we've seen one or two examples of people including within, in fact, oppression petitions and 994 petitions, courses of conduct that go back. That used to be the classic thing that people used to do. They used to go right back to the very start. In fact, they would say, they would want to include all the stuff about why it's a quasi-partnership, right from the very foundation of the company more than 12 years ago, etc., etc., etc. Nobody's ever taken the point. You can't do that.
No, the fact that quasi-partnership started more than 12 years ago is clearly something which you can say.
But only
you've got to establish a quasi-partnership.
That's the Southern Counties point.
You have to establish the quasi-partnership from when the agreement was entered into at the outset, unless it arises subsequently. So clearly that can happen 30 years ago. I've been in business with Mr. Chasey for 30 years.
Yeah.
You can't say, well, you can't bring a petition because the quasi-partnership arose more than 30 years ago. But I can't say, he did me a wrong 6 years ago and that was it. Sorry, 7 years ago, and that was it, and I want to claim money from him.
But going back to the point that my lord was discussing with you before, do I understand that your position is quite straightforward, and it's the same point in all these present tense provisions, whether it's Section 210 of the 1948 Act, or just and equitable, or Section 140A in the Smith case. You say it's not that there's no cause of action. Of course, the applicant has to establish their cause of action in the sense of establishing the facts that give rise to the remedy. The difference is that there's no question of limitation because there's no gap in time between when you have to establish those facts and the proceedings.
Yes, because
you have to establish them as at the time when the court pronounces it.
And that's demonstrated, my lord, you're absolutely right, demonstrated by the completed relationship case in Smith, where you have your cause of action, even though it's still a current tense analysis, you look at the is at the end of the date of the relationship.
Yeah.
So you do, and therefore you do.
Then you do have scope for limitation, as Lord Legate says.
Absolutely, yes.
Yeah.
Now, as for the relief, Section 140B provides a list of remedies, which are all the remedies. So it's not one of these, you can do whatever you like, without prejudice of generality, you can do these things. This is simply 7 possible remedies that are given, one of which is money, the others aren't money. Now, in the Priory Garage case, in the Hill and Spread trustee case, in our case, Section 241, Section 425, Section 996 don't do that. They give the court an unfettered discretion in 241 and 425 to restore, to make such order as it thinks fit to restore the position it would have been. Here, such order as it thinks fit to remedy the unfairness. And then it provides, without prejudice to the generality of the foregoing, a number of options. 425 and 241 both do identify one of those things as money. But if it hadn't identified it as money, but you claimed money, my learned friend's position would be that the fact you've got it in the statute means it's caught by Section 9.1, could be caught by Section 9.1. But where Section 996 does not identify that, somehow that takes it outside of Section 9.1. Notwithstanding that this court has determined in the last round of this litigation that compensation is available as a remedy under Section 996 for a breach by directors of the duty to owe the company which causes loss to the shareholder. But that would be a misreading of Section 996, which gives them the widest power, and would be, frankly, an absurdity. The court says you can have this remedy, but it's one for money, plainly one for money, but it's not listed as an example, and therefore Section 9.1 doesn't apply. That would be an absurd interpretation, with all due respect. Because if one asks the question, which Lord Justice Peter Gibson posed in the Farmisier decision, by virtue of what is this sum recoverable? And the answer is plainly by virtue of Section 996. That is the power of the court gives, and would otherwise be in the most remarkable triumph of form over substance. As to Mr. Justice Mann's decision in the Royal Mail claimants, in paragraph 191, he correctly recites the words of section 9.1, any sum recoverable by virtue of an enactment. Then in section 193, he falls into error by saying the damages claimed were not a sum recoverable under a statute. And that is not the right test. And we say he's simply wrong when he says that the statute must identify as an available remedy a money relief. It was suggested, I think, that the look and see approach from Misier, etc., doesn't apply here. Well, it does, with all due respect. You start with section 8, it's an action under a specialty. Then you look at the relief that's actually being sought. Is it a claim for money, recoverable under statute? Yes, by virtue of the statute. Yes, then you go to section 9. So look and see can absolutely apply here. I should say, my lords, on the cause of action point, the case below was argued on the basis the cause of action accrued on the 11th of July 2016. It's not, there's no respondent's notice that's been put forward by learned friends to allow them to advance this new suggestion that there is no cause of action. And as...
no, Mr. Chase, to clarify my misunderstanding, that's not his argument. He doesn't say there's no cause of action. His argument is his cause of action will accrue on the date when the court gives judgment.
Sorry, my lord, but we ran the argument below is ran on the basis the cause of action did accrue on the 11th of July 2016. So he now wants to run an entirely different case, which isn't covered by respondent's notice. It's a bad case, so perhaps it doesn't matter that there's no respondent's notice. But it's not there. And then, of course, your Lordship, Lord Justice Arnold rightly said, well, so you have a cause of action which instantaneously disappears. So it merges. The moment it comes into existence, it disappears. It merges in the judgment. It simply can't be right. Unless I insist on those grounds, I just want to touch very briefly on the two other grounds, if I may. Ground 2A, my learned friends fall into error in suggesting that if ground 2 fails, ground 2A fails. That's not right, because ground 2A says it's section 2 or section 5 by analogy if we have to move away from section 9 of the Limitation Act.
You only get into analogy if the claim is for an equitable remedy. If it's not for an equitable remedy, you don't get anywhere close to analogy.
Well, no, we don't need to go.
Well, I follow, but it's not a claim in contract. It's a claim under the statute.
Yes.
You can only get the limitation period for contract in by analogy, and the only power the court has to draw the analogy is a section 36 power, and that only arises if the claim is for specific performance, injunction, or other equitable relief.
But if it's
so unless you're going to say that what is being claimed is equitable relief, we're simply outside section 36.
We are, but section 2 or 5 would apply because it's a breach of duty claim, which doesn't fall within section 21. So where else does it fit in the statutory scheme under section 2 or 5?
The duty, oh, I see.
So we say
there's no question of analogy.
No, sorry. Did I say?
You did say by analogy, and that's I just didn't understand.
My apologies, my lord. So if it doesn't fall under section 8 and 9, and it doesn't fall under section 21 because that's a beneficiary claim, then where does it fall? It falls under section 2 or 5 as a breach of duty claim, because all breaches of fiduciary duty are generally caught by section 2 or 5. As to ground 2, we simply note they failed to address the fact that they made no allegations of fraud as against the directors, by the directors as against the company. We don't address that. And finally, Lords, as to ground 4, your Lordship, Lord Justice Lewison, suggested that Rule 2.2 of the Company's Unfair Prejudice Application Proceedings Rules, 2009, can be read so as to modify statement of case in CPR 17 to include petitioner points of claim. And it will not have escaped this court's attention, I hope, that this application was expressly brought under CPR 17.2 in the application notice, my lord. So clearly at the time they brought their application.
Just give me a reference to the application notice.
It's supplemental bundle, tab 6, page 56.
Tab 6.
Tab 6, page 56, my lord.
Thank you.
So there is support in your lordship's analysis found in my learned friend's application. My lords, unless I can assist any further, that is all we have to say in reply.
Thank you very much. Well, I mean no disrespect when I say the waters are very muddy. So we will take time to consider our decision. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says. It will be your opportunity to correct our grammar, our English, but not our reasoning. And we would hope that in the light of the draft order, you will be able to, draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree a formal order, please make short written submissions. We will make the order that we think is appropriate. The hand down of the judgment, when it eventually takes place, will be done electronically, remotely, by release to the National Archives and email to the people on the distribution list, and there will be no need for any further attendance. Thank you all very much.
Sorry.